much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the wonderful Kevin Estevez, an Arizona construction lien law expert. Today's webinar topic is Lien and Bond Claim Masterclass, everything they don't tell you, but should. So without further ado, I'd like to introduce the fabulous and incredible Kevin Estevez.
Thank you, Jessie, for the wonderful introduction. Hi, everybody. My name is Kevin Estevez. I'm an attorney at the law firm of Holden Willits in Phoenix. And we're going to talk today about lien and bond claims and go over some of the basic steps about securing your lien rights, the rules and exceptions to bond claims, and then some tips and tricks. But before we get into that, if you have any questions during the course of this webinar, please go to the chat box on the right, and we will save our answers to all questions until the end of the webinar. And please do not include any names, company names in the questions. I've kind of touched on this already, but the agenda for today is number one, securing your lien and bond rights. Number two, lien and bond rules and exceptions. And then number three, lien law traps to avoid. And lastly, we'll touch on SunRay resources at the end of today's presentation. So first things first, let's talk about securing your lien and bond rights. Contractors and suppliers have various remedies for circumstances when they're not paid in connection with construction projects in Arizona. Two of the most effective remedies are mechanics liens and payment bond claims. In most situations, contractors and suppliers must timely serve a proper preliminary 20-day notice to preserve these claims. So in most circumstances, your 20-day notice is your key into the world of mechanics liens and or bond claims. So when we talk about preserving and securing your lien and bond rights, that's the most important step in Arizona. First step off the bat, and something you've got to do in virtually every circumstance. So except for laborers for wages, every lien claimant and some Little Miller Act bond claimants in Arizona must serve a preliminary 20-day notice. And we'll get to the distinctions about which Little Miller Act bond claimants have to serve 20-day notices in a little bit. But what happens on the projects where either for liens or bond rights, a 20-day notice is required? If you do not serve a 20-day notice, you forfeit all lien rights. You can serve an untimely 20-day notice, and doing that, and we'll talk about this in a little bit, in a little bit more detail in a second. If you serve an untimely notice, you'll forfeit a portion of your lien rights. So notices can come late, but there is a cost potentially to serving a notice late. What preliminary 20-day notices are designed to do is give the owner advance information of the identities of any unpaid claimants who may perfect liens against the property if their debts remain unsatisfied. What needs to be in a preliminary 20-day notice? Pursuant to ARS 33-992-01C, preliminary 20-day notice must contain the following information. First, description of the labor and materials that will be furnished and an estimate of the total price thereof. The estimate of the total price thereof is a key factor that we'll come back and talk about a little bit later on today. The name and address of the person furnishing the labor or materials. Next, the name of the person who contracted for the purchase of the labor or materials. An adequate description of the job site for identification and a specific statutory quote-unquote notice to property owner prescribed by ARS 33-992-01C5. Incidentally, ARS 33-992-01D includes a sample 20-day notice that must substantially be followed. So once you get your 20-day notice, once it's put together. What do you do with it? And it, pursuant to Arizona law, it must be served on the following parties: the owner or the reputed owner of the property, the original contractor or reputed contractor, the construction lender or reputed construction lender, and the person with whom the claimant contracted. Should be addressed to the recipients at their residence or business address and served via either 1, first-class mail with a certificate of mailing, or 2, registered or certified mail with postage prepaid. 20-day notices are deemed served when they are deposited in the mail. The best practice is to serve a 20-day notice within 20 days of first commencing work or furnishing materials on a project. And that's because a 20-day notice reaches back 20 days. And if it's late, as we talked about before, the coverage will be limited. Late 20-day notice, like I said before, can be served. But if you do that, you're going to forfeit lien or bond rights for labor and materials furnished more than 20 days before the service of the notice. An example of this is if a subcontractor first furnishes labor or material to a project on March 1st, but neglects to serve a 20-day notice until March 30th, it will only have lien rights for the material furnished on or after March 10th. And that's because, as set forth at the top of this slide, the 20-day notice reaches back 20 days. So if you do it within the first 20 days, you should do it as soon as possible, but if you do it within the first 20 days of starting work on a project, it will reach back to cover the entire time frame, going back to when you started work on the project, and they go forward into perpetuity on the project, provided you don't have to amend the 20-day notices, which is something we'll touch on in a little bit. All right, next category of things we're going to discuss today is lien and bond rules and exceptions. This first slide here talks about the distinction between mechanics liens in Arizona and payment bonds. On private projects, mechanic liens a certain ownership interest in the real estate on which the project's built, and this is done on the grounds that the claimant provided services or materials to improve the property but has not been paid. There's a few exceptions to where liens can be recorded. Liens cannot be recorded on public property, and we'll talk about that with respect to payment bonds in a minute. An owner-occupied residence cannot be liened in Arizona unless the contractor or supplier has a direct contract with the owner. And in circumstances where a project is being built for a tenant, the contractor or supplier may only have lien rights against tenant improvements. With respect to bond claims, because as set forth above, public property cannot be liened, federal and state law requires payment bonds on projects of a certain type and size. Qualified subcontractors and material men may have claims against the bond if they satisfy certain notice requirements, and we'll get to all that in a minute. Generally, a lien must be recorded within 120 days after project completion. And when we say project completion, that is the completion of the entire project. So if you are a trade that performs work early in a project, like maybe you do excavating or things of that nature, your deadline to record a lien, provided you've served a 20-day notice and you haven't waived rights, will be from 120 days after completion of the entire project. Completion for purposes of Arizona law usually occurs 30 days after a certificate of occupancy is issued on a project. So in that circumstance, you have 150 days after the certificate of occupancy, because completion is 30 days after the certificate, and then you have to record within 120 days after completion. If no certificate of occupancy will be issued, completion occurs on the last day when labor or materials are furnished. So in that circumstance, you'd have 120 days after labor or materials are last furnished. If completion can also occur if work stops for 60 days and the stoppage is not due to a strike, shortage of materials, or an act of God. And so in that circumstance, you have effectively 120 days after the stoppage of work on a project. If the work stops for a reason that's not identified here, this completion occurs within 60 days, and then you have 120 days after that date to record your lien. One circumstance, and this can be a trap for the unwary, that you have to be mindful of is in Arizona, our statutory scheme allows owners or others to post a notice of completion in connection with a project. And this can shorten the deadline to record a lien to 60 days after the notice is recorded. But the owner must provide a copy of the notice of completion to every person who served a preliminary 20-day notice. So it's going to be recorded, and then a copy needs to be furnished as well. So you've recorded your lien. What happens next? You must serve the notice and claim of lien. Pursuant to ARS 33993A, lien claimants are obligated to serve a copy of their notices and claim of lien on property owners within a reasonable time of recording. The term serve requires that the service be made by first-class mail, registered or certified mail, with the sender obtaining a certificate of mailing, receipt, or registration, or receipt of certification. But service may also be made in the same manner that process is served. The phrase "a reasonable time after recording" is not defined in Arizona law, but you always want to be in a position where you serve your notice and claim of lien on the owner in accordance with the statutory requirements as soon as possible. You want to record the lien and get it served right away, so you don't run into an issue where your lien may not have been served within a quote-unquote reasonable time of recording. Next slide, we're moving on from liens, we're going to talk about payment bond claims. And those have certain notice requirements as well. On the Federal Miller Act, laborers and material men with no direct relationship to the general contractor furnishing the payment bond must give written notice to the contractor within 90 days from the date on which the person did or performed the last of the labor or furnished or supplied the last of the material for which the claim is made. Under Arizona's Little Miller Act, any claimant who has a direct contractual relationship with a subcontractor of the contractor furnishing the payment bond, but not a contractual relationship express or implied with the contractor, has a right of action on the payment bond on giving the contractor the following notices: a written preliminary 20-day notice that we talked about earlier, and then a 90-day post-completion notice that is given within 90 days after the claimant last performed work or furnished materials. And so the distinction there is under the Federal Miller Act, you have the 90-day post-completion notice. Under Arizona's Little Miller Act, you have two notices. If you are a party in the construction chain that was required to give notice, in Arizona, you got to give a 20-day notice, and then you got to give a 90-day post-completion notice as well. And here is a chart that talks about who is covered on bond claims and who has to give notices. So in this chart, you have the general contractor along the top, who's going to be the party for purposes of this example that issues the payment bond. You'll see the layer immediately below the general contractor. You have a first-tier subcontractor, and they are protected under the bond. And you have a first-tier supplier; they're protected under the bond. And because they have a relationship or privity with the general contractor who furnishes the bond, they aren't required to give notice. Under the first-tier subcontractor, you see a second-tier subcontractor and a second-tier supplier. They are also protected under the statutory Miller Act bonds, but they must give notice. And as you recall from the first slide, in the context of a Federal Miller Act bond, they must give the 90-day post-completion notice. And in the context of an Arizona Little Miller Act bond claim, they must give both the preliminary 20-day notice at the outset of work and the 90-day post-completion notice. And then the folks down here at the bottom are folks that are not protected under a payment bond that would be issued by the general contractor. Next is you got to know your deadline to file suit to foreclose on the lien or recover against the bond. A lien claimant must sue to foreclose on its lien within 6 months of recording. A foreclosure asks the court to order the sale of the property to satisfy the lien. Claimants with valid liens share the proceeds. If no foreclosure action is filed within 6 months, the lien expires by operation of law. And it can be confusing sometimes when you're talking about mechanics liens, because if you recall a few slides earlier, we were talking about 180 days, 150 days. Those are the deadlines for post-completion recording the lien. The deadline to file suit on the lien is 6 months. Not 180 days, it's 6 months. Payment bond claims. You must, whether it's the Federal Miller Act or a Little Miller Act, you can't bring a lawsuit prior to 90 days after the last of the labor was furnished or materials were supplied. Also, the statute of limitations for filing suit on a bond claim expires 1 year after the date the claimant last performed labor or supplied material. So an important distinction with bonds is, bonds are measured from the date on which you last perform material or last perform labor or furnish material. Mechanics liens, for purposes of the deadline to record the lien, is completion of the project. With the notice requirements on bonds, you're giving notice when you last do something, and then in flowing with that same idea, the statute of limitations for a bond claim expires 1 year after you, the claimant, last performed work or supplied material. Lien law traps to avoid. This will be the last topic we cover today. 20-day notices. We talked earlier about the context of 20-day notices, and we talked about what goes into it. One of the things that folks need to stay on top of is, if you issue a 20-day notice and you do everything right at the outset, you get lien rights to 130% of the estimated amount in the 20-day notice. If you recall from the slide earlier, one of the things that you're required to include in the 20-day notice is an estimate of the total value of labor and or materials that you're going to furnish to the project. So if you put $100,000 for case of example, if you have $100,000 estimate, and the work on the project you're working increases by $10,000, well, you have 110. Because you have $100,000 in the preliminary 20-day notice, you have the lien rights up to $130,000. But if the amount of your work on the project increases beyond that, then you got to do a supplemental 20-day notice. So it's important to track your 20-day notice amounts. It's important to document and change work. And if the contract is increased beyond this limit, the 20-day notice should be supplemented. The supplement should come within 20 days of furnishing the additional labor or materials, and the supplemental notice must set forth the new estimated total price, no piecemeal supplementations. And so that's the trap for the unwary here is, you don't want to do, if you have $100,000 initial preliminary 20-day notice and the work increases, the value of your work or materials increases by more than 130%, so say maybe $40,000, to the point where you need to, total value is now 140, and you need to supplement your 20-day notice. The new estimated total price in the supplemental notice should be $140,000. It shouldn't be $40,000. And so that's what I mean by no piecemeal supplementation. Next thing you want to be careful for is not inadvertently waiving lien rights or bond claim rights through submitting lien waivers. On the right side of the screen here, I've identified the 4 types of statutory lien waivers that are prescribed by Arizona law. and they can be found in ARS 33-1008D. You have the conditional waiver and release on progress payment. You have the unconditional waiver and release on progress payment. You have the conditional waiver and release on final payment. You have the unconditional waiver and release on final payment. And then on the left side is, I'm sure most folks in the industry are generally familiar with the payment application process, but I've put it here in graph form for purposes of illustrating a potential issue that can arise. And that is, so for purposes of this example, you're a supplier in a project or a subcontractor, and you submit payment application number 1. And in connection with payment application number 1, you're going to submit a conditional progress waiver for payment application number 1. And that'll have a through date. So with the statutory form, you're going to say, hey, my payment application, let's say it came at, was submitted on March 25th, and this waives claims for payment through March 25th. And say you submit that, and then for whatever reason, there is a dispute over your payment application and it doesn't get paid. And then you're moving on, and why that dispute is being addressed, it comes time the following month. So now we're in April 25th, and it's time to submit your payment application number 2. And with payment application number 2, you're going to submit a conditional progress waiver with a through date. And in that circumstance, if you put the through date of April 25th and don't include in the waiver that you're reserving your rights to payment application number 1, there's at least an argument that you've waived your rights to payment application number 1, because the through date is April 25th, and you still haven't been paid on payment application number 1, which was submitted in March and still hasn't been paid. So I know it can be, there can be a desire to get applications submitted and move things along, and get down and have processes where you are streamlining things to make things efficient. But you really have to be careful on your lien waivers, because if you do, and in the example I gave, submit a waiver that waives rights through that April 25th deadline, but you still haven't been paid on March 25th, then you've opened yourself up to a fight now with respect to whether you've waived rights for the March payment. And of course, when we say conditional, that would be you'd submit that April 25th conditional waiver, and then you get paid on that, and that would be the argument, because that's what you call lien waiver math. A conditional waiver plus a check operates as an unconditional. And the last sort of trap for the unwary that we'll talk about today is multi-building residential projects in Arizona. So we talked earlier about the deadline to record your mechanics lien being from the completion of the project. A distinction from that is on a multi-building residential occupancy project. For example, a multi-building condominium. Each building in that circumstance is a separate work, and the time within which to perfect a lien by recording the notice of lien commences to run on the completion of each separate building. So if you have a condominium development and it has several different buildings that are going to have condominium units in it, for purposes of recording your lien, completion occurs at the time each building is recorded, even though if your work as a subcontractor is for all the buildings under one contract with the general contractor. So that is something you need to be careful if you're doing that type of work, because you may think otherwise, well, hey, we're good until the whole project's complete, and that may not be the case. And so that's all I have substantively today. As I say at the end of every presentation, Arizona statutes and case law relating to the construction industry are full of detailed technical requirements and exceptions. This presentation cannot substitute for specific legal advice. If you have questions or concerns relating to any aspects of mechanics lien bond claims or any other phase of laws relating to the construction industry, please consult a qualified attorney. And with that, we'll open it up for questions.
Well, first of all, Kevin, as always, you really are incredible. So thank you so much. We do have a couple questions that have come through. The first one that has come through, it says, can you amend a lien if you are still within your deadline?
Yes, a lien can be amended within your deadline. Yes, and there may be multiple ways of handling that. But yeah, if you're within your deadline, you can amend the lien.
Okay, wonderful. And then this next question, it kind of relates back to what you were just speaking about. It says, if you're working on common space for a homeowners association, does the lien need to reflect all unit owners and sent to each of them, or just to the homeowners association and its registered agents?
That's tricky. It depends on, I think, a couple factors. Number one, it depends on how the development is, what stage in construction the development is, and also, I think you probably want to look at the CC&Rs on that to see who are the owners of the particular areas that you're working on. Typically, you may be able to look, depending what county in Arizona you're in, and determine who, if in fact the owner is the association, but there's an argument too that the work done on those things may benefit other parcels as well, and so. I hate to give a typical lawyer answer, but it depends. It depends on the certain circumstances.
Okay, not a problem. Thank you for trying to work through that one. All right, and then another question. It says, when working on a public job and I need to send the Miller Act, I cannot send it before 90 days, as you stated, from my last day. But when do I have to send that by? So I guess when is that outside limit?
So it is 90 days. You have to serve the 90-day post-completion notice within 90 days. You can't sue on the bond before the expiration of the 90 days. So maybe that was the hang-up.
Okay, well, thank you for making that clarification. All right, I do believe that's all the questions that have been asked. Can you go to the next slide for us?
Sure.
If anyone does think of another question that wasn't addressed, please feel free to reach out and we'll be sure to answer any questions for you. Sorry, I didn't say that prior. All right, and then here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Please remember each state has its own unique lien laws, rules, deadlines, and document types. So if you are doing work in a state that you are not familiar with, please go to our website. You can check it out, select which state it is, what role it is, what type of a project, and we'll kind of list out what documents are needed and what those deadlines are. There's project information sheets that will help you kind of obtain that information early on when you're first getting your contracts, and that way you know who is involved in that project and what some of those details are so you can better protect yourself. All right, so go ahead and go to that next slide for me, please. All right, if you guys don't mind, give us a quick review on Google. It really does only take about a minute of your time, but we really appreciate it. Any feedback you guys are able to provide to us to help us make sure that we're bettering our content and what it is that you're looking for. All right, and then the next slide. And with that, that is all we have for you guys today. Thank you so much to everyone who was able to attend. We hope to see you at our next webinar. Thank you again, Kevin. You really, really are fantastic. So I appreciate it. I hope everyone has a beautiful sunny day. Thanks, everyone.